Recording in progress.
Good evening. This is Mary Ellen McKay, Chair of the City of Nashua Zoning Board of Adjustment, and this is the October 24th, 2023 Zoning Board meeting. This evening's meeting will be conducted in a hybrid format. The meeting is accessible in person in the third floor auditorium of Nashua City Hall, 229 Main Street, and via Zoom at the link posted in all public meeting agendas. Attendance via telephone is available using the Zoom connection details. Minutes of tonight's meeting, as well as audio and video recordings, will be available later at the NashuaNH.gov/Agenda Center. Select Zoning Board of Adjustment. If anyone has a problem accessing the meeting, please call 603-589-3056, and they will help you connect. In the event the public is unable to access the meeting via the methods mentioned above, the meeting will be adjourned and rescheduled. The chair is in control of the proceedings and calls upon all who wish to speak in order as their raised hands are observed. The board follows the meeting protocols and procedures identified in its bylaws. The applicant will present their case for 15 minutes, followed by questions by the board. Next, persons wishing to speak in favor or with questions or opposition will be asked to speak for up to 5 minutes. If there are questions or opposition, the applicant will have 5 minutes to present a response. Finally, one and only one person with questions or in opposition will be permitted to speak again before the board deliberates and determines an outcome. A timer is used to manage speaking time. Kate Poirier, our zoning board coordinator, will notify us when 1 minute is remaining, and again when the speaker's time has expired. If you are participating by Zoom and wish to speak when public input is requested, please use the raise hand option, which can be found under reactions on a computer or the more menu on a phone. The chair will call you in turn. Please use the lower hand option when you have completed your question or comment. Please mute your microphone until called upon to speak. Note that all votes that are taken during this meeting shall be done by roll call. Tonight we will be hearing requests for deviation from the Nashua Zoning Code in the form of applications for special exceptions and/or variances. A special exception is a request that seeks permission to do something that the zoning ordinance permits only under special circumstances. To grant a special exception, 5 points of law are required to be met. These are outlined in the application and will be summarized in board motions. A variance is a request that seeks permission to do something that the ordinance does not permit. Variances also have 5 points of law to be met, different from those for special exceptions. Per the City of Nashua's bylaws and State of New Hampshire revised statutes annotated, a minimum of 3 or more affirmative votes are required to approve any application. In addition, this board will hear all scheduled cases if a quorum of 3 voting board members is present at this meeting. Any citizen has the right to contest the decision that this board makes. Should we render a decision that you believe is in error, you have the right to request a rehearing. A written rehearing request must be received by the City of Nashua Planning Department within 30 calendar days from the date of decision. Should this board not grant a rehearing request, you can file an appeal directly to the New Hampshire Superior Court. Please contact Mr. Falk of the Planning Department for more information. For this meeting, we have the following full board members in attendance. Myself, Mary Ellen McKay, Mr. Rob Shaw, the Vice Chair, J.P. Boucher, our Clerk, Jay Minkara, and Steve Lionel. We also have the following alternate members in attendance, Mr. Josh Nihili. In addition to board members, we also have with us Mr. Carter Falk from the Deputy Planning Manager, Ms. Kate Poirier, Zoning Coordinator, and Mr. Sam Durfee, our Planning Manager. We can start the meeting by taking a roll call attendance. Mr. Rob Shaw.
Present.
Mr. J.P. Boucher.
Present.
Mr. Jay Minkara.
Present.
Mr. Steve Lionel.
Present.
And myself, Mary Ellen McKay. I am present. Mr. Josh Hilly.
Present.
Thank you. Mr. Carter Falk. Ms. Kate Poirier.
Present.
And I see Mr. Sam Durfee back there also. Thank you. Mr. Falk, are there any changes to the agenda?
No, there are not.
Okay, the chair does have one change to the agenda. It is the order of cases to be heard. What is listed in our agenda as case number 5, the administrative appeal, will be moved to case number 1. And we will then follow in order. So at this time, I will read case number 1 into the record. Owner, NEH Realty LLC. Applicant, Regent Park Associates. Address 91 Deerwood Drive. Appeal of administrative decision. That an appeal was submitted within the 30-day time frame as prescribed by the Zoning Board of Adjustment bylaws. This case, I will call the first person, the applicant. I just wanted to reference, excuse me? I just wanted to reference that in speaking on this case, we have a very narrow scope. Our scope is, was the appeal submitted within the 30-day time frame? That is the only information we can listen to. That is the only information we can render a decision upon. With no disrespect intended, no other comments, should they be offered, will be accepted. The board has a very narrow scope, and we will remain within the scope of remain within our purview. That's the time frame. And Mr. Shaw, did you have a?
Just the logistically of how we'll hear testimony, just wanted to make sure you covered that for the appeal.
For the appeal?
Since we'll hear the appellant and
Correct.
then city staff, and then we'll ask for any other testimony.
Yes.
In support and
In
or
support,
against.
correct. Thank you. And that's why we have a
Which
vice
is
chair.
slightly different than our regular cases.
It's very different than our regular case, and it's something that we're all here. This is what we're supposed to be doing, and we're going to do. We will follow the law, and we will follow our bylaws. So at this time, I would ask for, I'm used to having the appellant.
Is that the point?
If you would please, sir, state your name and address for the record, and please speak into the microphone so that it can be recorded. If it's easier, please remove the microphone.
Thank you. Good evening, Madam Chair. Good evening, Board. My name is Dan Deshane. My address is 650 Elm Street, Manchester, New Hampshire, 405, and I represent the applicant, Regent Park. Madam Chair, I appreciate and respect your outline of the scope of this hearing, and will stick to my comments to that scope. Thank you.
Thank you very much.
I think that this case, there actually aren't that many factual disputes, and I don't believe there's a dispute on the governing law. So I'd like to focus my presentation on what I think the key facts are and how they've been interpreted. Much of this is in the file already. As stated, this appeal was filed regarding an administrative decision that was made in November 2022 about whether 91 Deerfield needed to go through site plan review relative to becoming a crematorium. Ultimately, it was decided by the planning manager that it did not, that he could administratively approve the amendment and change in use. There's no dispute that that happened in November 2022. There's no dispute that no notice to abutters was issued during that time frame. Okay, so that's the past, so to speak. The next thing that happens here, as far as the applicant is concerned, is they issue a notice pursuant to 325A, which is a statute that requires those looking to build a crematorium to notice abutters. And that notice was included, Mr. Durfee had some attachments to his, are all the submissions before the board, and you have those packets? I have handouts too, but if you already have those, obviously I will rely on that. That notice, the statutory notice that I'm referring to, is very brief and simply says as follows, and again, this is an exhibit to Mr. Durfee's submission. It says, "Dear Sir or Madam, in accordance with New Hampshire RSA 325A33, we provide this notice of our applying for a building permit with the City of Nashua to install a crematory at 91 Deerwood Drive." So the notice just refers to a future application for a building permit. That's the entirety of I read you the entirety of that notice. Eventually, Ms. Deborah Chase, who's here tonight on behalf of Region, becomes aware of this, and she writes to the city. Again, that communication is referenced in my pleading, but it's also attached to Mr. Durfee's submission in full as Exhibit 2. So she writes him, it is July 5th, that she writes him and says, "Good morning, would you be able to tell me regarding the crematorium that's going in across from our apartments on Deerwood Drive, if the permit has already been approved or when it will be approved, and will there be any public meeting to discuss this?" That's what Mrs. Chase writes with respect to this issue. To his credit, Mr. Durfee replies almost immediately and writes as follows to Ms. Chase. Again, this will be at the top of your page on the exhibit. It says, "Good afternoon. The permit from the crematorium was administrative in nature and required no public hearing or planning board approval. Use is permitted by right in the district and has been approved." Now, Ms. Chase receives this. What Mr. Durfee says is the permit from the crematorium was administrative in nature. We're not talking about a permit that was issued in November 2022. What we're talking about is an administrative decision. The permit involved here is the building permit. The building permit had not been issued at that point. The building permit in this matter was not issued until July 21st, 2023. Okay, so there's some confusion relative to these communications about what exactly is happening at the property, whether the building permit has been issued or not. At that point in time, my partner, John Sokol, was retained and called Mr. Durfee on July 13th. And those communications were included as well. And they're discussing the issue of what happened here and whether it went through site plan approval. Mr. Sokol asked for some plans and did ask Mr. Durfee if he would reconsider his decision from November 2022 regarding the administrative appeal. And he declined. At that point in time, the next thing that happens is the building permit actually is issued, and we receive a copy in timely fashion on July 21st, 2023, as I mentioned. And our appeal is filed 18 days later on August 8th. So when I referenced the, kind of an agreement, the facts that I'm giving you are all, I believe, undisputed. The email communications you have in front of you and speak for themselves. So the position, I believe, of the city, and I'm sure Mr. Perlman as well, who also has a submission here, is that they're not taking the position that the 30-day window runs from November 2022, from the date of the date the decision was made. because there's an acknowledgement that none of that notice is given to any of the abutters, including my client, or any other abutter for that matter. But they are saying that, Mr. Durfee is saying that deadlines should run from when my client, acknowledged receipt or knowledge of the use of the property. And then, as I understand, has calculated the 30-day, which is found in your bylaws, 30 days from that date, which was the July 5th communication I read to the board. So our position is, so that's the nuts and bolts of it. Our position is, while certainly on July 5th, we became aware that there was a crematorium going in, there's no indication and no reasonable abutter would understand that there was an administrative decision made back in November 2022 to to administratively approve the site plan amendment. And that's the crux of the appeal. The crux of the appeal is not anything other than that, is when did my client know that the appeal, excuse me, I have a parent in the hospital, so I apologize for that. I'll make my remarks brief. The appeal is solely based on, did my client file the appeal in a reasonable period of time after they became aware of the November 2022 administrative decision. And I would respectfully suggest to the board that the communications on July 5th, which were submitted by the city, don't give any reasonable abutter any kind of indication of the underlying administrative decision that led to that point. Now, I will tell you that the building permit eventually issued on the 21st, as I mentioned, of July. My client timely appealed that to a to-be-constituted building board court of appeals. But their scope of review, as you probably know, is fairly limited as well. And certainly when I take this issue to them relative to the administrative decision in 2022, they might not take that up. I think that's fair to say. That board has not, to my knowledge, just in the interest of full disclosure, been constituted yet. I've heard from the city that they're doing that, but that's where that sits. We have not had a decision or discussions about the scope of that review. There's been no proceeding whatsoever in that regard. And no counterfiling by any party either. So when I tell you what the arguments might be, I'm really just trying to share with you the best of my knowledge and expectations of what they might be. So so our appeal is that once we became aware of the underlying administrative decision of November 2022, we filed within a timely fashion and within the 30-day limit or 30-day period set forth by the ZBA. So that's as simple, I think, as I can lay out the facts and the law. There are some issues here that go beyond this hearing, obviously. Obviously, the crematorium statute is not a perfect one, and if there's no ability to challenge certain things, why would crematoriums not be, the first thing that the first time that a person finds out about the crematorium is when they find out about the building permit pursuant to the statute. And there's no indication, quite candidly, in the statute or the case law about what they're supposed to do about that or what rights they have. That's just not been developed in New Hampshire. I will assure the board that I have researched the issue and had other people research the issue. So we're dealing with a little bit of a novel situation here. But I would suggest to you that novel situation shouldn't work to prejudice my client, the appellant, or any other appellants, excuse me, any other abutters. And that I just want to share with you that tension is certainly probably unintended by the legislature, but it's just where we are, and that's the state of the law right now and the state of the statute, quite candidly. So again, I've done my best to provide you hopefully with a relatively tight presentation. I'm happy to hear any questions if you have them for me.
Does anyone have any questions? Mr. Lionel.
Yeah, we're not here about the building permit.
Exactly.
As you have stipulated, a representative of Regent Park Apartments was made aware on July 5th about the administrative decision.
I
And-
didn't
and
stipulate
you-
to that, sir, I'm sorry.
A representative of Regent Park Apartments was made aware on July 5th that an administrative decision had been made. That's part of the material that you submitted and stipulated to. That a building permit was later to be filed is not relevant to what we're here for, which is the appeal of the administrative decision. The statute says, or the bylaws say, an appeal, 30-day time period is counted in calendar days, beginning with the day the zoning administrator or his or her designee made a decision, or at least, to your benefit, made representatives of Regent Park Apartments aware of that decision. That date is July 5th. The rest of it doesn't seem relevant to me. Can you talk to that?
I understand your question, thank you. I would point back to the communications of July 5th, sir, that you're referring to. The communication from Mr. Durfee on July 5th states, "The permit from the crematorium was administrative in nature and required no public hearing or planning board approval." There's no, what happened in November 2022 is not a permit. The only, my point in raising the building permit issue is the only permit at issue in this overall case is the building permit, and that had not issued as of the date of July 5th. There had been no permit of any type issued. So I would suggest to you that this email 1215 on July 5th, in saying that the permit from the crematorium was administrative in nature, does not give the ordinary abutter notice of an administrative decision back 8 months earlier to forego site plan review. And that's actually the crux of our argument, sir. There's no reference to that administrative decision in November, and there'd be no way without further investigation or discussion for my client to know that. And like I said, I appreciate it might be just a wrong turn of phrase in Mr. Durfee's email, but there's no permit that was at issue in that letter, excuse me, as of that date. Does that answer your question, sir?
Your response was fine. Thank you.
Mr. Shaw.
I would just like to follow up, because I'm also to Mr. Lionel's point. And I feel like perhaps there's weight being given to issuance specifically of a building permit. But if I look at the last sentence in Mr. Durfee's email, it says the use is permitted by right in the district and has been approved. I take that as the decision. Nothing to do with whether a permit's been issued or not. So to me, that seems like a statement that implies that the city made a determination and an approval. So I guess I just want to see if you have any further comment on that.
Well, I appreciate your point, sir, and I can just share with you that's not how my client read this email. They did not have an understanding at this point that there was an administrative decision to forego site plan review. And taken in total, I don't think that that's, I would suggest to you that that reading is similar to any other abutter in the city. I don't think that's to be and to Mr. Durfee's credit, when Mr. Sokol showed up on the 13th, they had free and open conversations, and certainly isn't about how anyone has conducted themselves, and that's not the nature of my appeal, and that's not the nature, there's no accusations or anything of that nature. I'm not suggesting that at all, or deliberate attempt to do anything. That's not my point. My point is based on the plain language of this and the relatively unique situation we find ourselves in, that we are, in a situation where we are appealing a decision made at this point even 8 months prior.
Thank you.
Anyone else have any questions? No further questions.
Thank you for your time. I appreciate it.
Thank you. Is there anyone here
Yeah, the city presents.
City first.
City first. We will now hear from the city. Please. Please state your name and address for the record, sir.
Thank you. Sam Durfee, Planning Manager for the City of Nashua, here at 229 Main Street in Nashua. Facts were stated. I'm not going to refute any of those, and I'm just going to get right to the point. This seems to be hinging on some confusion around the term permit in the emails. Ms. Chase's email on July 5th refers to the permit. Her email did not include any attachments, specifically the attachment on the July 13th email from Mr. Sokol, which did have a scanned copy of the building permit notification as required by the RSA. I'm in the planning office, not in the building office. So the permit, in my mind, is relevant to the application for administrative review. This is the application, the permit requested for an approval of a use. So in my email, the use is permitted by right in the district and has been approved. That is the permit application for the change in the use. So when I see, has this permit already been approved, I'm thinking this is the permit for the use, the administrative change in use. I'm not the building permit. If Ms. Chase had asked any further questions, we would have been happy to provide any and all information, relevant documents. There was no follow-up until July 13th with John Sokol. He then did attach that mailing. We had multiple back and forth conversations about this. We kind of got to a level of clarity, but then the record speaks for itself, timing the filings and all that. I think that's really the issue to clarify based on the testimony before. Happy to answer any questions.
Mr. Shaw.
I guess I'm just going to essentially ask you to reiterate, since I asked the question of the appellant. So to you, and I had stated, I thought that sentence that you just even restated is essentially your position that the decision was made the determination was made and a decision was made to that effect. Is
Correct.
that correct?
I would agree with that, yes.
Okay, all right, thank you.
No other questions?
Excuse me.
Oh, I'm sorry, I didn't see you, Mr. Boucher.
Mr. Durfee, just in general, notification, or there was, the appellant had mentioned notification to normal abutters of administrative decisions. That is not, can you just explain that so that everybody can hear exactly what does or does not happen when an administrative decision is made?
So regarding notification of administrative decisions, so there's no statutory requirement. There has been no past practice, and we typically do go above and beyond in terms of our notifications. If we were to notice every single administrative decision, and these really span the gamut depending on the project, what's being requested. I sign off on administrative decisions every single day. And then to apply some sort of a notice requirement to those would not only be an added cost to us, the city, or the applicant, but also the cost of added time and delay. If we were to set like a notification time period, we do not do that.
Thank you.
Thank you. Thank you, Mr. Durfee. Is there anyone here who wishes to speak in favor of this application? Is there anyone here who wishes to speak in opposition to this application? And I'm assuming there's nobody on Zoom.
Nobody raised their hand.
Nobody raised their hand. Okay. You would have notified me. Please state your name and address for the record, sir.
Madam Chair, Andy Perlman, attorney with Prudinger and Perlman, here in Nashua on behalf of NEH Realty Limited Liability Company. And Madam Chair, members, some of you may be glad to know I don't have a lot to say. We provided a letter to the board dated October 18th where we documented that Regency Park received notice of the, under the statutory 321A, of the intent to obtain a building permit on June 30th. And then there was nothing from June 30th until July 5th. And you've heard that discussion about the emails back and forth on July 5th, but I just want to emphasize that, you know, when in doubt, we lawyers who do this, we practice conservatively. If there's ever a doubt of timing or deadlines, you file early, not late. We believe the application was filed late. So, thank you.
Does anyone
Any
have any
questions?
questions? I see no questions. Thank you very much. Is there anyone here who wishes to speak either in favor or in opposition? Seeing none, I'm going to close the public hearing, and I'm going to open the public meeting. Mr. Lionel.
In my opinion, it's very clear that the applicant was notified on July 5th, and therefore the appeal was not timely.
Thank you. Mr. Neely.
I concur with Mr. Lionel. In my opinion, I would have started the clock on June 30th. I think Mr. Durfee was more than fair by giving those extra few days. So I'm not in favor of this.
Thank you. Mr. Boucher.
I also believe that the clock expired. According to our statutes, November is really the date that the decision was made. I think, again, we're giving the benefit of the doubt. I believe the date is July 5th. So that's my position.
Thank you. Mr. Shaw.
Yeah, I likewise feel like July 5th was a reasonable communication that a decision was made. So I'm not in support of this appeal.
Mr. Minkara.
I also agree. I think the appellates received actual notice of the permit. I think they did the appropriate thing in reaching out to the city. But when I see the response, from the planning department, it was really pretty clear that a decision had been made. And I think it was generous to count the 30 days beginning of the 5th. And pretty clearly, those 30 days expired.
Thank you. And myself, I concur with my fellow board members. When I look at this, I see that anything prior to June 30th of 2023 or July 5th, when Mr. Durfee stated his decision would be considered effective, has no bearing. Plus, with zoning, we deal with variances and special exceptions. We generally don't deal with permits. And so that seemed to me that when Mr. Durfee did state that the use is permitted by right in the district and has been approved, that was succinct and it covered it. And so I agree that the clock started ticking on July 5th. And now, would somebody, or the chair is going to make this motion, I think. The chair will make the motion based on evidence presented and understanding of the decision we need to make by the full board. It would be to deny the appeal of the administrative decision made by the city of Nashua.
I'll second.
Thank you, Mr. Lionel. Mr. Nolan,
Can we have discussion?
is there any discussion? Mr. Shaw.
Yeah, and I would like to make sure, so that it's kind of on the record, even though we just talked about it, specifically under the discussion of the motion, that I think the board unanimously feels that a decision was made on July 5th, and that the appeal was received outside of the 30-day window subsequent to that July 5th date. So I just wanted to make sure that was clearly understood.
And I would concur with amending the motion
Yep.
to state that categorically
agree.
and clearly. And thank you, Mr. Lionel, for agreeing. All right. Mr. Lionel, how do you vote?
Mr. Lionel votes in favor of the denial.
Mr. Boucher, how do you vote?
I'm sorry, I don't mean to hold things up. I'm just reading this, I'm not understanding, or I don't agree with, I know what we want to do, but if we read this, and it may be out of order, but it says that this appeal was submitted with the decision pursuant to Land Use Code Section 19-36, that appeal was submitted within the 30-day time frame as prescribed. I would say that we are approving that it was within the 30-day time frame.
No,
I didn't
the
hear that.
motion was
No.
to deny.
Yeah.
It's not within the 30-day timeframe.
Okay, all right, I'm sorry. I want
Yeah.
clarification.
No.
All right. So, and I apologize again.
No, that's fine.
My vote is to deny,
So you vote in favor of the denial?
yes.
Thank you. Mr. Shaw, how do you vote?
In favor of the denial.
Mr. Minkara, how do you vote?
In favor of the denial.
And myself, Mary Ellen McKay, I also vote in favor of the denial. Where's Attorney Duchesne? The board has unanimously determined that the appeal was outside of the 30-day appeal notification timeframe, therefore violated the bylaws of this zoning board, and at this point, that will be the decision to deny the appeal. And I would assume any decision made by this board may be appealed within the 30-day timeframe by any person who decides to challenge a decision of this board. Thank you for your presentation, and thank you for your time this evening.
Thank you for your consideration.
Thank you. Now, is everyone good to go? We will proceed with case 1 on our sheets, but now case 2. Owner, David and Alina McAlpine, Revocable Trust of 2017. Address 101 Connet Road. David and Alina McAlpine, Revocable Trust of 2017. Owners 101 Connet Road, Sheet C, Lot 691, requesting the following. Variance from Land Use Code Section 190-31 to encroach up to 4 feet into the 6-foot required left side yard setback, and 2, variance from Land Use Code Section 190-264 to exceed maximum accessory use area, 40% permitted, 44% proposed. Both request to construct a detached one-level 24 by 24 two-car garage. This is in the R9 zone in Ward 5. Is there someone here to present this application? Please step to the microphone, sir. State your name and address for the record.
My name's David McAlpine, 101 Conant Road, Nashville, New Hampshire. Good evening, Madam Chair and the board.
The floor is yours, sir. You have up to 15 minutes to state your case.
Okay. I need permission to build a one-level 24 by 24 foot. On the application, I said two-door garage. Probably more accurate to say two-car garage. I'm probably going to do one big, large garage door that goes up. That will be located less than 15-foot offset rule from the property line as was discussed. It'll be roughly 2 to 3 to 4 feet from the property line offset. The only reason I say that is just because my fence that I have on the property line is already offset 1 foot from my neighbor's property. So I left a buffer of 1 foot there. And I measured, and it would be, I have some leeway with a few feet this way or a few feet that way, so, you know, down to the last foot is where, you know, it is kind of weird. There's some question maybe on my part. But I was able to use the tool that you have at the planning department, the GIS tool, and I was able to visually show the 24 by 24 foot footprint of what that garage would look like. I have kind of a narrow kind of pie lot on Conant Road. There's gonna be it's gonna be detached from my house. There'll be like a corridor or like a walkway between the garage and the house. The garage footprint will be set forward a little bit more than the house, slightly more than the house. And basically sit on most of the existing footprint of the upper part of my driveway as it stands now. And I'm doing this because my wife and I we're getting a little bit older. I didn't note this on the application, but I just thought I'd mention it too. 3 years ago, I fell down the stairs of my house and I'd ruptured my quad tendon. And I usually keep my snow blower in the back where the shed is, and the back of my property kind of goes up on a slight, like on a hill, on a slight, I don't know the angle, but as you walk into my backyard, it goes up into like a hill. And just the muscle around my snow blower from the shed, you know, I worry about falling sometimes as well. So, you know, that's another thing that I wanted to consider. I had a neighbor on Searles Road that also had a similar situation to me, and they had, the garage will basically look, it's gonna have the same kind of siding that my house has. It'll be the same color as my house. I'm even gonna try to match the shingles. I had a picture of the structure. I gave kind of a picture to the planning department of what it's gonna look like. It's just gonna have a kind of a sloped roof in the back. There's gonna be there's gonna be a gutter on the back to divert the water.
Mr. McAlpine?
Yeah.
You need to just probably get back closer to the mic. No, that's
Closer
just-
to the mic, sorry.
Yeah.
You can pick that up and take it
also
out
we
of
have
Oh, I
that-
can take
we-
it up.
And we
Okay.
also do have your image up on the.
Oh, wow, I can do karaoke now.
Your image is up on the screen too.
Okay, great. Oh, you got it, okay. So, and obviously I just want to protect my vehicles. It's not going to be anything that particularly fancy. My goal is just to protect my vehicles and to have my snow blower in the garage and some equipment that I'll be able to easily access to clear snow and take care of my yard. Like I said, one of the main reasons my wife and I were discussing it is that going up on that hill during a snowstorm and potentially slipping and falling, or right now I have to kind of drive my snow blower up the hill a bit, and I don't want it to roll back on me or anything like that. So that's like another reason why I was thinking about it. And getting a major operation was a big deal for me. So it's something that I think about all the time. But I'm just hoping that I'm aware of the rules and everything of the city, and I really I respect them. But I also think that this will improve my property. I discussed this with my neighbors and my neighbors across the street, and actually my neighbor Ryan that abuts my property on the side of the house where the garage is going to be was okay with it. And that goes to not interfering with his property, and the structure, as I was saying, would be in a style in accordance with my ranch, same siding color. The roof will be slanted back as it was shown in the picture. The garage structure will protect our vehicles, like I was saying, that was like point number 3. I was answering the question for number 4. I believe the garage will enhance the value of my property and the homes around my property. And I think, I know I was being verbose, but I think as I just leaf through some of my answers to the questions, I've kind of addressed them all with what I have to say. And, I welcome any kind of questions or concerns or that sort of thing from the city or the public. Thank you for your
Mr.
time.
Lionel, I saw your hand first, and then Mr. Minkara.
Yeah.
Just a quick question.
Sure.
Had you considered making this garage an attached garage? Is there, what's stopping you from doing that?
Yeah, we were thinking about attaching the structure to the house. We had done a lot of, we did some work with the stairs to our back door. We put a new rail, and we enhanced the steps with some granite to kind of protect them. They were like cement stairs in the past, and we kind of dressed them up, and we just thought it would be to kind of preserve the work that we had already done, to the house over the years. We put in a new flower box, a window box on that side of the house. So I'm just thinking if the garage was attached directly to the house, it kind of takes away from some of the other things that we had invested our money in, and we just thought if we'd have like a corridor between the house too, that it would be a way to preserve some of the nice things that we did to the house, and it would be kind of a neat look for the house.
Okay, thanks.
Thank you. Mr. Minkara.
That was my question.
Okay, fine. Are there Mr. Boucher and then Mr. Neely?
So I'm estimating, but I could be wrong if you let me know, there's probably going to be 4 feet between the house and the garage?
Yeah, roughly, I measured, about 4 feet between the house and the garage, yes.
All right, thank you.
Yeah.
Mr. Neely.
It sounded like earlier, and I may have missed it, it sounded like you said your fence is offset towards inside your property line by about a foot? Does that sound
Yeah,
right?
by about a foot, yes.
And then it sounded like you said it'd be about
I would say 2 to 3 feet on the application, and that would be be like, if you added that foot on the other side, that would make like 4 feet
4 feet.
from the property line. And I've had this, when I put in the fence, I had to get, what do you, I'm trying to think of the word for, when you have the person come out and.
Surveyor?
Surveyor, I had a surveyor come out to put to check, there was to put in a pin if it was missing and, check the pins, so I know exactly where my property line is, on both sides, all the way around. So there's actually a pin at the bottom, kind of around where my neighbor's mailbox is, like, just on my side of the property.
So you did have a surveyor come and remark
Yes, I
the
did.
lines? Okay.
Yeah, and that would have been around 2014 or so that I had that done.
So, I'm sorry if I could ask one more question. So, your neighbor's house definitely skews towards that side of the property. So when you look at the front of your house, based on the fence to his house, is that about 6 feet, would you estimate, or 8 feet, or?
So from the side of his house
Yeah.
to the fence?
Yeah.
There's a good, I'd say maybe 10 feet, I'm thinking, to the fence. Or 9 feet maybe from the side of his house to the offset. Now that you asked that question, wish I would have measured that, but there's a fair amount of distance.
All right, thank
He
you.
actually has like an extra foot, really, because I offsetted it from the line, so it looks like he's got an extra foot. And actually towards the back of the lot, he's got, I gave him more of an offset on that because we're at the tie in the fence, so,
Thank you. Mr. Minkara?
If you were to attach the garage on that side of the house, are there any windows, utility meters, or anything else that would be impeded or would have to move?
No, because all my utilities are on the other side of the house, or on the opposite side of the house from where that driveway is. All my utilities are in the corner there.
And no windows that would be blocked?
No windows would be blocked.
Thank you.
Mr. Shaw?
I want to just go back through a little bit of your history, and I might also want to ask staff a question on this. So
Sure.
It seemed that maybe when you were doing the application, it seemed like you were under the impression you had a 15-foot side yard setback you had to meet, because you talk about 15 feet a couple times in your application, but obviously it's only a 6-foot setback. But what I'm a little bit also confused about now is it seems that you're talking about that you would really only be 3 to 4 feet offset, or you would actually be, 3 to 4 feet offset from the property line, not just 2 feet. Because the application, at least interpreted, I believe, by city staff in the version we get, and what gets published, it says, that you will encroach up to 4 feet into that 6-foot side yard setback, which means your plan is to possibly leave only 2 feet from the edge of your garage to your property line, which...
No, it would be, it would be about, it would be 3 to 4.
Okay. So,
It would be 3 to 4.
So
All right.
2 feet. And
so
26.
let me just, can I just... check?
Absolutely.
Yeah, if staff can help out here, because I feel like that maybe there's some confusion in calculation, and I just want to make sure we've got the proper sense of this, so if you could, if one of you could help out.
We had it, based on the plan, a 4-foot encroachment, or up to a 4-foot encroachment, that's how we advertise it. Wherever he wants to put it within, up to that point is fine, whether it's a 4-foot encroachment, a 3-foot encroachment, 2-foot encroachment, if the property line is a little bit offset from the garage, We just had it up to a 4-foot encroachment, so as long as he's 2 feet away from the property line, wherever the fence is, that's all okay.
Okay,
It sounds like what he's talking about, that
Yeah.
it would meet that.
yeah. Yeah, I want to be like about at least 2 to 3 feet away from the fence. And like I said, the fence is actually offset 1 foot on, towards my property. I mean, right, and in the line, the actual line is actually on my neighbor's property. So there's like that foot on his side between the line and the fence, so.
Right, I understand that. And so I guess I just want to note to you, I'm struggling a little bit because, and I think we all had this same question. I didn't get, it got asked early on about, why not make it an attached garage? It sounds like if you made an attached garage, you wouldn't even need the side yard setback variance. We haven't really talked about the fact that there is an accessory use of, by building it as a separate structure, it also kicked in the second variance. If it were to be attached, that would no longer be applicable. And it's a fairly low overage, so the board hasn't even covered that. You didn't really talk about it in your testimony. I'm not really concerned about that from meeting the kind of criteria. I think it's pretty minor, and I wouldn't have a problem with that. But I just want to note, I'm struggling some because I don't know how much real need there is to actually have to encroach when it seems that it's reasonable to attach the garage. But what I'm also hearing is that you really are probably much more likely to be only 2 feet encroaching into that side yard setback and leaving 4 feet to the property line.
Yes.
Which I must say I'm much more comfortable with.
Yes.
And I feel like that's much more reasonable.
Yeah.
So it sounds like you'd be okay with that. I don't know if the board's, well, let me ask it this way. For you, would you be okay if the board said, we're okay approving up to 2 feet encroachment? In other words, you have to leave 4 feet to your property line.
4 feet to the property
Yeah.
line.
Would that work for you? The board might choose not to make that
Yeah,
stipulation.
I think that
Okay.
would work, because, while preparing for all this too, I was talking to a potential builder. I haven't I haven't signed any kind of contract or anything, but Ryan Rush, and he came down and we looked at the area and what I wanted to do, and he was even, and he was telling me, it could be done without a problem. The other thing is on that side, the land kind of goes up where my neighbor's house is too. So the garage, my house and the garage tend to be a little kind of lower anyway. It wouldn't interfere with any kind of view that my neighbor would have. And that's where the bedrooms are in his house anyway. So it's not a side of the house that, he doesn't wouldn't be interested in looking out when he looks out his windows, he just sees my house and driveway anyway. So he didn't seem to have a problem with aesthetics or what he was looking at. But I know that's not part of your question, but yeah, but I'd be okay with that if you said I had to be 4 feet from the property line. I don't think that would present a problem.
Okay, thank you.
Thank you.
So-
Mr. Lionel.
Yeah, I want to get back to this, the question about why it's not a attached garage. And I want to point out that one of the points of law that we are required to consider is the special conditions of the property and the benefits sought by the applicant cannot be achieved by some other method reasonably feasible for the applicant to pursue other than the variance. What I'm hearing is that it would be feasible for you to build the garage attached to the house. If you did that, the property value would go up because people like attached garages. And I haven't heard any reason for not doing that other than you've done some work previously in the house that you don't want to disturb. Now, how does one get to this short walkway?
Well, part of it has to do too with just the way my deck and the landing is in that area. In the way that obviously, if you did attach it, you had stairs inside that would go up to the door. I'm thinking it would, to me, it would disrupt the flow of the house because of the way that those ranches were. So you have the landing, you take one step up, and you have this small, like, I want to say 4 by 4 foot landing, and then you have like another step that goes into my kitchen. And then I have like, structurally, I have heating vents on each side. I just remodeled my kitchen. And, I could, I'd have to it'd disrupt the way that I even have my deck, because I would have to blow out a window or something to put a French door or a sliding door or something, and then do a new deck, because if I do the garage that way, it would just disrupt, it would just disrupt that whole area the way it is now. And I don't want, that's part of the reason why I didn't want to attach it. And when I had discussions with the planning department as well, one of the things that I will be doing with the garage is fire-rated walls. I'm going to do everything that's required by the city as far as the structure goes. But it just attaching it to the house would cause trouble with the way that the house is structured. And it's a kind of weird thing. If you just look at the ranch from the road and you see the steps and going into the house, you would think, well, why doesn't he just attach it? And it's kind of because of that, where that landing is. And then from that landing, you can go down the stairs to the basement, and then I'm like saying there's like another step that you take, and that's the main floor of the house, which when I first was interested in the property and I bought it, I thought that was a little weird, but that's the way those ranches are, and all my neighbors' ranches kind of are, is that there's kind of that step up, and it would just be too disruptive. I'm thinking to other things the way they are currently. Like I'd have to definitely redo my deck, and like I said, I'd have to blow out like a window on that back wall of the kitchen to put a sliding door, a French door that would go to that deck or something.
So is your plan to have access to this garage from the deck?
No, from the outside. I wanted to just access it, just to go down the steps. And kind of like on the GIS map, it doesn't really show it that well.
No,
It's
it
like
doesn't,
a gray
which is why.
square kind of behind the house, that's where the deck is. And then if you were to, in that back corner, there would be like a landing, and then there's some steps. And the reason why I positioned even the garage the way I did is I just, if you were going to get the mail or something, you'd walk between the house and the garage, and then you'd just hook a quick left and then a quick right up the stairs and into the back door of the house, which is what we use the most, is the back door instead of the front.
Okay, 'cause I thought I had heard you say something about a covered walkway. Did I mishear that?
We're not going to cover the walkway. The walkway won't be covered.
Okay, so the garage will just have a door into it from the outside?
We were thinking about putting a door in the back of the garage.
Okay.
Yeah, so if you're in the garage, you'd open up the door in the back of the garage, and then you'd just enter the house in the back door that way. But if you were in the kitchen and you wanted to go get the mail, you just go between the, through that corridor and, or from the deck for that matter. Or if you were on the deck, you'd step on, from the deck, you'd step on the landing and then down the stairs and then to the driveway.
Okay, thank you.
Yep.
Mr. Boucher.
Just one quick question.
Sure.
Just to clarify what Mr. Mancara had asked you. So basically, on the left side of the house, you have no doors and no windows. On the left side of the house, the side of the garage,
So if I'm facing my house from Kona Road,
the left side of your
on the
house.
left side of the house, I have my back door, and then the only other window right now is like it's kind of high. It's like just for plants, just like a plant kind of window.
Okay.
But I was even talking to the builder, and if need be, I could put I could just put a regular window there, but it wouldn't interfere with the walkway at all because it's so high.
So the only reason I'm asking you is I just wanted to know if there was an existing, I just want to make sure, because I saw something there, I just want to make sure that that wasn't going to really eliminate, if you had several windows there, that'd be one thing, you'd be eliminating a lot of light and stuff to a room, but right now you answered my question, so you just
Yeah.
have basically just a door and
Yeah.
a window that, or a plant window that you're getting a little light for some plants or something.
Yeah.
Okay, thank you
Yeah.
very much. I appreciate it.
Yep.
No further questions? We have no further questions, sir.
Okay,
Thank you.
Thank you. Thank you for your time.
Is there anyone here who would like to speak in favor of this application? Is there anyone on Zoom is there anyone here who would like to speak with questions, comments, concerns, or opposition to this application? And there's no one on Zoom. So hearing that, I'm going to close the public hearing and open the public meeting. Mr. Neely.
For similar type cases, one of the criteria I've always used to really judge this is how far away the neighboring house is from the property line. That led to many of the questions here. 103 Conant certainly is close to the line. We heard testimony, it's about 9 feet to the fence. And then from the fence to the proposed garage is, we'll say 4 feet, so that takes it up to 13 feet. I certainly have some pause. I get where the board was going with the potentially attaching to the side of the house, making the attached garage. That would be my preference as well. However, without the neighbor at 103 here stating any type of opposition, I'm in favor of this application.
Thank you. Mr. Boucher.
So this property, I would say that there is a special condition to the property. I don't think it's a major special condition. If you want to categorize it, I think it's minor. I think, again, it's somewhat of a pie-shaped lot. It's a little narrow position of the house. I think it's reasonable to ask for a two-car garage. I would be definitely in favor of Mr. Shaw's comment on minimizing further minimizing the incursion into the setback. But, and again, I think the property line is slightly at an angle, but I don't think it's really going to be somewhat, something more dramatic where we've noticed something different in the past. I think, again, attached garage, again, depending what size you build, I think this is a reasonable size. It's not an oversized garage. Again, access to the house, again, a lot of times you'll see, a lot of times, not all the time, but a lot of times you see two garage doors, one big garage door with a door on the side, so you don't have to open that garage door. So again, I'm looking at that space between the house and the garage. There would definitely, to me, one way or another, would have been, if it was me, this is my opinion, at least 3 feet, somewhat to walk in without having to open the garage door. With that being said, I think, again, I think it's reasonable for the request to put a two-car garage. I would be open to, again, maybe minimizing the incursion in the side setback.
Thank you. Mr. Shaw?
Yeah, I guess I am struggling somewhat still, again, as I noted, I think in my question, just because I'm not convinced that this can't be done without the variance, as noted, by doing it as an attached. I feel much better about minimizing the encroachment to the side yard setback. I guess still want to kind of hear the rest of the board's comments, but I'm not convinced yet. But I definitely think the two-car garage request is a very reasonable use, and it's not an oversized garage. So I think to ask for it to be narrower is going to, it makes it very difficult to do a two-car garage that's not any wider, or it's less wide than this proposal. So so I guess those parts of it I'm fine with, again, I noted before, and we haven't talked about it much, I think if we go forward with any kind of approval, I think the overage as far as the accessory use being 44% being asked for versus 40% allowed is relatively minor, and I don't think would be noticeable to an average person. So I think that part of it would be fine. So
Thank you. Mr. Minkara?
Yeah, I agree that the use, two-car garage, is reasonable, and it's certainly not an oversized garage. And the encroachments and the overage that are requested aren't great. But I still can't get there because you, in fact, can attach the garage. There's just nothing to prevent it. There aren't, in some of the other cases that we've seen, windows on that side of the house that would be blocking light to the house. There are no utilities that would have to be relocated. It doesn't seem to be really any hindrance on the property of any consequence. A garage could be attached whether there's an internal connection or not. So you could change the floor plan of the house or alter it in some way to connect internally, but you don't need to. Obviously, there wouldn't be any connection internally now. So for that reason, I just can't get there. I can't find support.
Thank you. Mr. Lionel?
Yeah, I'm sort of where Mr. Shaw and Mr. Mancera are, that I don't have a problem with the size of the garage. I don't have a problem with the overage of accessory use area, but I can't get past the requirement that we would have to say there is some special condition of the property and that you can't do it some other way other than requesting the variance. And it seems to be clear that he could attach the garage, just doesn't want to. And it doesn't even have to create a door from the house to the garage. That's, as Mr. Mancera said, that's not a requirement. I'm really having difficulty with this.
Thank you. Well, in this one, I agree, the size of the garage is not an issue. It's a reasonable request. The accessory use is minimal. Most people wouldn't even know there was an accessory use, on the property, so that goes without saying. However, when he discussed that small window and then a door right there on the left side, and having a door in the back of the garage so that it wouldn't inhibit the space and the ability to utilize those steps, it sounded like those steps went up and at an angle or to a different side. There was a couple different levels, and that may be an issue. Plus, the incline of the property, so the topography, and if it's a pie shape, it's a little strange. And when you put up a fence, we all realize you give that extra foot on the other side, so that if you have to paint your fence or repair it, you are standing on your property as opposed to someone else's property. And that's why that foot is there. So even if his fence was here, he's still here. So, and his neighbor, the neighbor who would be the most impacted, is in agreement with him building this garage this way. He's not in disagreement for them to be in the neighbor's home looking at the view, measuring things. The neighbor took all of the avenues afforded to him to see if he would lose any view, if it would have an impact on his property. And his feelings, his thoughts were it would not. And so I'm in support of what this gentleman would like to do. Okay, would somebody care to make a motion on this application?
I'll make the motion.
Thank you, Mr.
See where
Lyon.
it goes. Okay. I'd like to make a motion on behalf of David and Alina McAlpine Revocable Trust of 2017. Address is 101 Conant Road, Sheet C, Lot 691, requesting the following variances. From Land Use Code Section 190-31 to encroach up to 4 feet into the 6-foot required setback, but I think we had discussed that we would change that to 2 feet. That's, okay. So 2 feet into the 6-foot required left side yard setback, and variance from Land Use Code Section 190-264 to exceed maximum accessory use area 40% permitted, 44% proposed. Both requests to construct a detached one-level 24-foot by 24-foot two-car garage. This is in the R9 Zone, Ward 5. I guess I'm going to do this as if we were going to approve it, and we'll see where it goes. Okay.
Thank you.
So the board believes this variance is needed to enable the applicant's proposed use of the property. Given the special conditions of the property, special conditions being the layout of the narrow lot, the position of the house on the lot, the layout of a rear deck and doors, and that the benefit sought by the applicant cannot be achieved by some other method reasonably feasible for the applicant to pursue other than the variance. The board finds this is within the spirit and intent of the ordinance. We do not believe it will adversely affect the property values of surrounding parcels. It's not contrary to public interest, and substantial justice will be served. So I'll make a motion to approve these 2 variances.
Do I have a second? Thank you, Mr. Shaw, for your second. Mr. Boucher, how do you vote?
Mr. Boucher votes in favor.
Mr. Shaw, how do you vote?
Mr. Shaw votes against, not in favor?
Not in favor. Mr. Minkara, how do you vote?
Mr. McCara votes not in favor.
Mr. Lionel, how do you vote?
Mr. Lionel votes not in favor.
And myself, Mary Ellen McKay, I vote in favor.
So
That's-
we need to do this again.
So,
We need to
yes,
make a
we would
motion
have to do
deny.
this again because the motion to approve failed.
Failed, okay. So I'll do this again. Make a motion on behalf of the David and Alina McAlpine Revocable Trust of 2017, address 101 Conant Road, Sheet C, Lot 691, requesting the following. Variance from Land Use Code Section 190-31 to encroach up to 2 feet into the 6-foot required left side yard setback, and variance from Land Use Code Section 190-264 to exceed maximum accessory use area 40% permitted, 44% proposed. Both requests to construct a detached one-level 24-foot by 24-foot two-car garage. This is the R9 Zone, Ward 5. The board believes these variances are not needed to enable the applicant's proposed use of the property, that there are no special conditions to the property that prevent the garage from being attached to the house, and if that was the case, neither of these variances would be required. So the board believes that the applicant can achieve the method, the desired end result with a reasonably feasible method other than the variances. The board believes that this choice is not within the spirit and intent of the ordinance. We have no testimony about of how it affects the property values of surrounding parcels. The board doesn't believe it will be contrary to public interest, and the board finds that substantial justice would be served. However, not all the points of law are met, and therefore I make a motion to deny these variances.
Thank you, Mr. Shaw, for your second. Mr. Boucher, how do you vote?
Mr. Boucher votes not in favor of the denial.
Mr. Shaw, how do you vote?
Mr. Shaw votes in favor.
Mr. Minkara, how do you vote?
Mr. Minkara votes in favor.
Mr. Lionel, how do you vote?
Mr. Lionel votes in favor.
And myself, Mary Ellen McKay, I vote not in favor of the motion. Mr. McAlpine, the application for the variance has been denied. Anyone has up to 30 days to appeal any decision made by this board. Should you have any questions, comments, and concerns, would ask that you please re-refer back to Mr. Carter Falk or Ms. Kate Poirier in the planning department. Again, thank you for your presentation, and I would just thank you for being here this evening to present. I'm sorry to say the board did not go along with it. The vote was 3-2. Thank you. Are you good to go, or should we break?
Okay.
Okay. Holly Ann Boyer, owner, 6 Crowley Avenue, sheet 29, lot 51, requesting the following: special exception from Land Use Code Section 190-119A4 to expand a non-conforming use by constructing a single-level 14 by 27 addition to the rear of the house, and variances from Land Use Code Section 190-16, Table 16-3, to encroach 8 feet into the 10-foot required left side yard setback, and 3, to encroach 6 feet into the 10-foot required right side yard setback for the addition. This is in the G1 zone, Ward 7. Is there someone here to present this application? Please speak into the mic, state your name and address for the record.
Good evening, Madam Chair.
You'll have to speak up.
My name's Holly Boyer. My husband's Steve Boyer. We live at 6 Crowley Ave, Nashua.
Okay, and it might help you, Ms. Boyer, if you would take the mic off of that stand and just speak into it. You're soft-spoken.
Thank you. Sorry.
Thank you. You have up to 15 minutes to present your case.
We're
The floor
looking
is
to do an
yours.
addition to the back of the house for one-level living for future. I have knee issues. I've already had a knee replacement, so going up and down stairs is a little bit challenging. So we would like to add a master bedroom on the back of the house with a bathroom and a closet.
So we're not really changing the footprint of the house except for it's pushing it out, that 14 feet.
Keep the mic, sir. Yeah.
Okay, we're not really pushing, we're only pushing the house out towards the back. We're not changing the footprint on the house as far as from side to side. And the actual measurement would be 26 feet across by 14 feet out.
And we would just like to say that these properties are on top of each other as it is. You sneeze and you're in the other person's yard. My parents actually own the house on the right of us, and they do not have any issues with us doing the addition. And we haven't heard any issues from our neighbors as well.
Thank you. Does anyone have any questions of the applicant? Mr. Shaw.
I think it's your parents' house then. It looks like it does also extend further back than yours. What would you say, by how much approximately? It's hard for me to judge from here. Looks like it's like 10 feet maybe, is that fair?
It's probably about 10 feet past where we
Yeah.
are now.
Okay. And have you had any conversations with, especially your neighbors at number 4, about your proposal?
We have talked, and we have not heard any
They haven't had any
issues.
issues with it.
Yep,
Thank you.
Thank you.
thank you.
Is there anyone here who would like to speak in favor of this application? I don't see anyone on Zoom. Is there anyone here who would like to speak with questions, comments, concerns, or opposition to this application? Seeing none. And again, there is no one on Zoom. I will close the public hearing and open the public meeting. Mr. Boucher.
I'm generally in favor of the application. Again, there's a lot going on this property. This little neighborhood is, definitely, as the applicant stated, the houses are on top of each other. Again, I think it's reasonable for what they're asking. Again, the incursion on the left and right side is going to be no greater than it is now. We don't have any problems with the rear yard setback. Again, this is an old existing neighborhood, predates zoning. So again, I'm in favor of the application.
Thank you. Mr. Shaw.
Yeah, pretty much for the reasons that Mr. Boucher just stated, and I think, it's the applicant's notation about looking for a way to achieve single-floor living by adding this structure in the bedroom and bathroom is I think, a reasonable request and understandable. And I think there is no way to reasonably do this without encroaching into these setbacks, just because of the nature of this neighborhood and the fact that they are just going to be following the existing footprint, if you will, from the side. So I think it's a reasonable request, and I am in support.
Thank you. Mr. Lionel.
I'm in support of the application for the reasons stated by my colleagues.
Thank you. Mr. Neely.
I am also in favor of this application for the reasons as stated by my colleagues.
Thank you. And myself, Mary Ellen McKay, I'm also in favor of this application for all of the aforementioned reasons. Oops. See, I forgot. He wasn't here yet. Mr. Minkara, I apologize.
I'm also in favor.
I write myself notes, and you hadn't shown up when I was writing all this, so I apologize. Okay. Would somebody care to make a motion? Mr. Shaw.
I'll make a motion on behalf of the owner, Holly Ann Boyer, at 6 Crowley Avenue, sheet 29, lot 51, requesting the following. Firstly, actually, we have both a special exception, so I'll do that motion first, and then we have the area variances. So the first is for special exception from the Land Use Code, section 190-119A4, to expand a non-conforming use by constructing a single-level 14 by 27-foot addition to the rear of the house. It is listed in the table of uses, as just noted. This usage will not create any undue traffic congestion or unduly impair pedestrian safety. It will not overload public water, drainage, sewer, or any other municipal system. The special regulations are fulfilled, and it will not impair the integrity or be out of character with the neighborhood or be detrimental to the health, morals, or welfare of the resident. And I move to approve the special exception.
Second.
Thank you, Mr. Lionel, for your second. Mr. Boucher, how do you vote?
Mr. Boucher votes in favor.
Mr. Shaw, how do you vote?
Mr. Shaw votes in favor.
Mr. Lionel, how do you vote?
Mr. Lionel votes in favor.
Mr. Minkara, how do you vote?
Mr. Minkara votes in favor.
And myself, Mary Ellen McKay, I also vote in favor.
Continue. Again, going to make a motion on behalf of Holly Ann Boyer, owner, 6 Crowley Ave, sheet 29, lot 51, requesting the following two area variances. The first is from Land Use Code, Section 190-16, Table 16-3, to encroach 8 feet into the 10-foot required left side yard setback, and likewise, similarly, to encroach 6 feet into the 10-foot required right side yard setback for this addition that was just described. The area variance is needed to enable the applicant's proposed use of the property, given the special conditions of the property. The benefits sought by the applicant cannot be achieved by some other method reasonably feasible for the applicant to pursue other than the area variance. It is of note, this is one of these neighborhoods that has homes that are built very close to the property line, and these encroachments are just following the existing encroachment of the existing structure. It's a reasonable request in that the desire is to have the option for essentially one-story living by adding a bedroom and bathroom to the rear of the house. And so this is the only way to really do that. Again, it's within the spirit and intent of the ordinance. There's no indication of any negative effects on surrounding parcel property values. It is not contrary to public interest, and substantial justice will be served. Therefore, I move to approve these two area variances.
Thank you, Mr. Lionel, for your second. Mr. Boucher, how do you vote?
Mr. Boucher votes in favor.
And Mr. Shaw, how do you vote?
Mr. Shaw votes in favor.
Mr. Lionel, how do you vote?
Mr. Lionel votes in favor.
Mr. Minkara, how do you vote?
Mr. Minkara votes in favor.
And myself, Mary Ellen McKay, I also vote in favor. Mr. and Mrs. Boyer, your special exception and your variances have been granted. Congratulations. Anyone may appeal any decision made by this board, and they have 30 days with which to do so. Should you have any questions, comments, or concerns, please refer back to either Mr. Carter Falk or Ms. Kate Boyer in the Planning Department. Again, congratulations, and thank you for your application. Okay. Cambridge Holdings Incorporated owner, Ted Cherry applicant, 55 Lake Street, U18 Sheet 99, Lot 30, requesting use variance from Land Use Code Section 190-15, Table 15-1, number 222, to allow an indoor recreation use for a rage cage / paint splatter room. This is in the RC Zone, Ward 6. And I see there are somebody here to present this application. Please state your name and address for the record.
Thank you, Madam Chair. My name is Ted Cherry. The address is 55 Lake Street in Nashua.
Thank you.
I'm Daniel Hutchinson, Mr. Chair's attorney. My office is in Haverhill, Massachusetts.
So I didn't hear that, I'm sorry.
My name is Daniel Hutchinson. I represent Mr. Cherry. My office is in Haverhill, Massachusetts, ma'am.
Thank you, Mr. Hutchinson. You have 15 minutes with which to present. I don't know whether you are going to do it or you're going to have your attorney do it.
I will handle most of it, and then if we need to work together, we'll work together. So again, my name is Ted Cherry. I own Rage Cage & H, which is currently located across the street on 10 West Hollis Street. We have been in business since we opened in February of 2021. So we are a rage room experience and a paint splatter experience. What we do is we allow people to work through their frustrations and anger. So we say to tell people to get it out in here instead of doing something stupid out in the community. People come in and they get a variety of glassware and electronics, all safety screened to make sure there's no hazardous chemicals or any negative impacts to the environment. And people come in to use handheld weapons to destroy the said objects. We also offer a paint splatter experience for excuse me, children and adults. We've had kids as young as 3 and adults up to the age of 93 come in to use our services for artistic expression and just fun birthday parties. So we are looking to move our location to the 55 Lake Street address to provide a better, safer location for our families and birthday parties. and to, excuse me, apparently I have anxiety all of a sudden. So basically trying to provide a safe, fun experience at a new location that offers a better facility and larger facility, so that way we can help more people and more families with fun and entertainment in Nashua. We have customers that come from all over New England. We actually have had a fair amount of international customers recently. We've had a family from Italy, Bermuda, and Germany this past weekend. So it's not the reason they come to New England altogether, but this is one of their top priorities when they do come here. Excuse me. So what we do is when it comes to safety and the structure of the neighborhood, we use sound dampening foam boards in between the walls, so that way with the sound of the crashing, the glass breaking, everything is muted with these. So we use, they're 1 inches, but we put them together so they make 2 inches in between the walls of the rage rooms, so that way we don't disrupt the community. And then when it comes to the paint splatter experience, we use safe, non-toxic washable paint, which washes out of clothes, out of hair, doesn't affect the environment in any way. Excuse me. I apologize for the delay there.
That's okay.
If I can step in.
Yes, please.
Sure.
So the structure of the business is not going to change substantially other than the location. They are going to expand the size. The hours are going to stay the same as what they are now, which is already approved for. They go up until about 9 o'clock at night during the week and up to 10 o'clock at night on the weekends. I'm pretty sure Mr. Cherry shared with the board a couple of letters he received from, I believe, psychologists.
So one nurse practitioner focusing on mental health, and then one licensed social worker.
So the other thing it's important to point out, it didn't make it into our presentation, other than the fact that I had a conversation with Mr. Cherry tonight before we came here, that somebody was murdered just outside of his unit 2 weeks ago. So he is looking to provide a safe community, because the expansion is also going to be, the paint splatter rooms are going to be for kids' birthdays. It's kind of hard to do that in a downtown location, whereas the industrial building that he's going into has some other training facility, experience, sports. I'll let you explain.
Yes, so we had just found out about this. So it is a medieval sports training business, which absolutely sounds fantastic, and we're looking into working with them to partner up with different events in the area, because I had no idea existed. And again, it's a really cool thing that Nashua has to offer, that we're building to bring cool new things to not only Southern New Hampshire, but Nashua in general. Especially when it comes to birthday parties, parents are so sick and tired of going to trampoline parks. I'm sure they're great fun. I've never personally been to one, but we offer a new and exciting opportunity for parents to bring their kids to something interesting and cool that they haven't done a million times already. And then, so, like I said, we're using the sound dampening products, the foam boards, to make sure that we do not disrupt the neighborhood. And bringing into a space that has currently been vacant, which for about a year at this point, bringing a new space that will bring that will allow us to have security and safety measures, and to make sure that we treat our customers to a safe environment that they deserve, which we do not currently have at our current location, based on the neighborhood and the residents nearby. Mr. Hutchins, do you have anything else?
So I can tell that the board that I don't believe there's an adverse impact to the community. I think there's an artistic value to what he provides at his location. He's done a lot of background work at the location that he's going to. He did sign a letter of intent, provide a $2,000 deposit to the property owner that you mentioned when you opened this hearing. He's looking to move forward with it. His plan is to be able to move in there on January 1st of this year, with your approval. He welcomes any questions you might have. I can tell the board that I came with Mr. Cherry to meet this young lady here to fill the application, and he was very thorough. And by the way, she was wonderful to work with. And I think that he addressed all the concerns within his application that the board required. Thank you.
Thank you. Does anyone have any questions? Mr. Shaw?
So it's more about, it's basically a use variance in that this is in the RC zone, and so it's not normally allowed. But I think what is key, and you've alluded to it by the one other business at least, but the property of interest, does it have other also what I guess would be basically non-conforming, non-residential uses there, and that this property is not being used for residential at this point in time, nor would be suitable for? Is that essentially part of the contention?
Correct.
Okay.
So there's no residential facilities in the building. The mill right in front or behind, however you categorize it, is all businesses. So there's Joyce Heating and Cooling, and there's probably about 20, 25 other businesses in that location. There's no other residential facilities there.
Okay.
Thank you.
And this is a kind of almost off the record comment, but I couldn't help but think about like rage jousting or something like that. If
I
you
know,
guys
right?
partner up, so.
So
No,
you
I will personally be going and trying the medieval training myself, now that I know it exists.
So you watch Maine Cabin Masters too, huh? They had the jousting.
Oh,
The medieval, yes, they did. Are there any other questions? Thank you for
Thank you, Board Madam
your
Chair.
presentation. Is there anyone here who would like to speak in favor of this application? I have 2 letters here that are part of the application. Do they need to be read into the record, or just do you want letters from and state the name?
Madam Chair, you can just state the name and address. We know they're in support.
Okay, yeah, they are in support. One is to Misha Malone. She's a licensed social worker, and she's the owner of Time for a Change Wellness LLC. And then we also have a letter in support from Jennifer Tawa or Tawa, APRN, and she gives her number. That's nurse practitioner. Okay. Is there anyone here who would like to speak in opposition to this application? Please step forward and state your name and address for the record.
Good evening. My name is Mark Weisflog, 55 Lake Street. I'm president of the board on the Lake Street Condominium Association. Just to clarify the building has currently about 25 owners. It is all industrial, commercial occupants. Residential occupancy is prohibited by the bylaws and the condominium documents. We have about 134 parking spaces, 152,000 square feet of occupied owner-owned space. This proposal, as good as it might seem, has never been brought to the board nor the management company. Some concerns that we have, just coming out of the gate, is the proposal I read from, that was, let's say, drafted by Mr. Falk, indicates 1,200 square feet of basement usage. The drawing that was accompanying that proposal indicates 3 spaces, B12, which is 2,290 square feet, B13, 2,220 square feet, and 1-8, which is 1,970 square feet. And there's a square footage of 4,510 square feet that is not in the condo rolls because it was a second floor added by the past owner, Skyscan Planetariums. They added a second floor to the boiler room, and that totaled about 10,900 square feet, not 1,200 square feet. The unit that's indicated on the application or the proposal, or the, let's say the synopsis, is unit 1-8. If you look, and I don't know if you have the drawings, But on the drawings, that would be indicated by the storage unit, which is not indicated as, maybe they use it as storage, but the rest of the spaces are encompassed by the other 3 spaces. So while 1,200 square feet might generate X traffic, 10,900 square feet is a lot more than that. One of the items that we have a concern with is any changes to the building need to be brought before the board, i.e. Design Review Committee, to make sure they keep the building in kind with what it's at now. The parking is problematic. We have 134 parking spaces. At 3 o'clock in the afternoon, there might be 13 to 15 spaces open for in and out traffic. The rest of the spaces are by people that work in the building. So the overload of that parking lot and how that flows over into Ash Street or Lake Street would be a concern of ours. One of the big concerns that we have, the building has no trash removal or common area trash removal, so that would have to be taken care of by the applicant, but there's no room for additional dumpsters. So our concern is you know, I'm sure they're going to generate some materials to get rid of, but best thing for them to do would be come to the board, present what they're thinking about they're doing, and at that point, we can tell them how we can handle the situation. I don't know if this is in the purview of the board, but if they could table the matter and have the applicant come to us and say, this is what we're proposing, because they can't just show up and think they're going to do something to the building. They're not going to, or they're not going to be able to until the board approves those changes. If it all works out, great. We'd like to have new occupants and people pay their rent. And they are going to be tenants of Cambridge Holdings, not, so they're like a normal tenant would do. That's all I got. Any questions?
I have a question of Mr. Falk. Since this is a condo association, what do we do in this case? I mean, and maybe it's a question for the attorney as well, were you aware it was a condo association?
So Mr. Cherry was not aware that there was any impingement on him moving in there via a board such as this. Mr. Cherry wants to comply with whatever the city and also the building asked for. And just to briefly address a couple of points, his hours of operation, he's closed on Mondays, Tuesdays, and Wednesdays. He opens at 3 o'clock in the afternoon until about 9 o'clock. So as he asserted to me previously, that he doesn't generally have customers, maybe 4 people in the afternoon. They're mostly weekends, when I think that a lot of the industrial people aren't working anyway. He has no problem working with them to figure it out. If you wanted to grant conditional approval, I have no problem working with this board. I mean, he's been, and if you look at one thing we didn't mention, he's been a great asset to this community. He's had no police or fire services rented to his property. He's a very responsible person, and he's done a great job just with the 2.5 years he's been over here.
Thank you. I don't think that's the question. I think the question was more, there's a board and association rules and regs, and then there's what we can do and what the city can do, and we need guidance to make sure we don't make an error in judgment as well.
No, I completely understand. Like I said, Mr. Cherry had no idea that there was going to be this next step, or we would have taken care of this before we came to you.
Thank you. So then, if this board was to determine that tabling this to give both parties time to discuss all of this, that would that be acceptable?
Do you think we'd be able to get to the next meeting?
That's a Mr. Falk question.
The next meeting is November 14th. That should be fine, as long as they can meet with the condo association before that time.
That should work.
Okay.
As long as it's okay with you guys, that's fine with us.
Then that's
So,
fine. Then
if the board
I,
wants to table it to a date certain to November 14th,
yeah.
pending the outcome of their meeting.
If that meets with everyone's approval, including the board, I'll make a motion to table this to the November 14th meeting.
Thank you for posting the variance.
I just, I need a second to my motion. Mr. Lionel, thank you. And since we have concurrent from both sides, I think that unless the board wants to just have a discussion on our motion, we can call for a vote. Mr. Minkara.
I'm, happy to vote in favor of continuing the hearing, but, I just want to comment that I do think that they're independent issues, and I don't think that any applicant has to follow whatever internal rules there may be in a building or in a homeowners association. So I do think they're separate, but nevertheless, I would certainly vote in favor of the motion.
Mr. Boucher, then Mr. Lionel.
You have your hand up first.
Mr. Lionel, then Mr. Boucher.
Well, I really want to agree with Mr. Minkara that if we grant a use variance, that doesn't automatically mean that the applicant can do whatever he wants. He still has to go through other processes, including apparently getting approval of the Building Condo Association. So I don't object to tabling it, but I don't think it's necessary.
Mr. Boucher.
I also agree with Mr. Lionel. To Mr. Minkara's point of view, I think there are two independent issues, whether or not they can work with the applicant. I think that what we have in front of us right now is an application. I don't think that our approval of this application changes what has to happen with the ownership or the management of that building. So again, I don't see any detriment to going forward as far as there's no detriment to the applicant, there's no detriment to ourselves. And I think that I would really want to just move forward with the application. Again,
Okay.
but I won't, but I would, if it was going to be a vote to table, I would support it if that's what it came down to.
And for me, a variance goes with the land, so it goes with the property. And,
This is a use variance.
well, there's that, but sometimes it's best to err on the side of caution. Mr. Falk.
Madam Chair, there have been numerous requests that the board has considered in which there are private restrictions, and as long as they meet the points of law for a variance or a special exception, that's really all the board should be concerned about. I mean, it's nice and it's neighborly to offer to table this so that those folks can meet together and agree on something, but there's been several times where we've had PRDs or maybe a property in the airport that get approval here, and they still have to get approval from a board or an association later on. So,
Or a planning board.
or planning board or any other board for that matter. So it's not required that we have all those approvals first before they come to this board.
Okay,
Yeah, if the board wants to table it, I guess it's no harm or anything. They've all agreed to it. We have a gentleman here from the board and the applicant and his attorney. Everybody's agreed to table it for a couple of weeks. I see no harm in doing that as long as everybody's okay with that. I just don't know if it really should affect the board's decision. There has been a motion to table it, and it's been seconded. Everybody hasn't voted on it. One option could be is to rescind the second.
I know,
motion,
I'm on the
and you
horns
could
of a
go forward
dilemma.
with the vote.
I mean, there's a piece of me that understands and sees that you could go forward, but then there's the other side of me that says there's two sides, and they're willing to speak without whether the board said yay or nay, and they can come to a clear consensus without the pressure or non-pressure of this board's weighing in first. So I think I'm going to leave my motion on the table and let us weigh in after the fact as opposed to before the fact, since everyone and the applicant is nodding his affirmation. So yes, Mr. Shaw?
Yeah, and I agree with the sentiment, and I'm not sure we really need to do this table either. The only thing I am thinking that maybe since there is general agreement, and especially since I'm hopeful that, there is a timeline of some concern. We heard about a January 1st date. Doesn't sound like that's necessarily a significant concern at this point, but it would actually be 3 weeks from now before we would meet again. But the one thing that does come to mind is perhaps by the discussion through the condo association, if there are any changes to the actual operational hours or that part of things that might slightly change the description of the use. So if for no other reason than that, I guess, and since there seems to be general agreement from the kind of concerned parties, I'll support the motion to table.
Thank you. Then, since the motion is on, is there any further discussion on this before I ask for a vote?
The second motion.
I did.
Mr. Lionel. Okay, so then I'm just going to, Mr. Shaw, how do you vote?
Mr. Shaw votes in favor.
Mr. Lionel, how do you vote?
Mr. Lionel votes in favor.
Mr. Minkara, how do you vote?
Mr. Minkara votes in favor.
Mr. Boucher, how do you vote?
Mr. Boucher votes in favor.
And myself, Mary Ellen McKay, I also vote in favor. So we will see you the 14th here in November. We've tabled it, hopefully, for the best interest of all concerned.
Thank you very much.
No, thank you very much.
And again, thank you for posting, because without that posting, we would have never known.
Well,
The sign.
That's why we
See?
do it. That's why the city
that's
does
why
it.
the city does that.
Good job.
Every now and then, we get it right, huh? Okay.
Madam Chair, can we take a couple of minutes?
Yes. We will take a 5-minute break.
And we're back.
We're getting punchy a little earlier than
I
normal.
think
Yes,
so.
we are.
You know,
I'm losing my voice, isn't that interesting?
I'll take the blame. Let's see. We are now with case number, the last case.
Perhaps if we do read the whole thing into the record, I would ask if the
Yes.
applicant is present.
Is the applicant from CJ Investments, Andy Erickson, either in person or on Zoom? Since I see no hands and nobody jumping up and down, without an applicant, we cannot hear the case. And so, at this, Mr. Falk, do we just leave it to the applicant to reconnect with the department?
I would just probably table it to a date certain.
So-
The next meeting,
November 14th?
November 14th.
What's that agenda look like?
Yeah. Well,
We have 3 cases plus a rehearing, and then
Now this table.
this one, and then the one we just heard. 5. So there'll be
5,
5
yeah.
and a rehearing request, which is not a public hearing.
that's kind of standard. So then we would have to table it to the very next meeting, or
Next meeting,
do we, okay, because I was
And
going to
if
say,
And if they cannot make it to the next meeting, they will let us know, and then it'll go to the following meeting.
okay, so
Then
then,
it'll have to be renoticed.
yeah, well,
Well,
not necessarily.
we don't like to keep tabling things to date certains, because then the neighborhood may not know. right,
Exactly.
Unless they're watching here.
I'm just saying, if they're not able to make the next meeting, then we would have to renotice
Then
it
we'd
because
renotice
it
it.
wouldn't have been tabled to a date certain.
Yeah.
That's what makes me reluctant to table it to a date certain, because the applicants aren't here.
Oh,
We've done this typically, though, in the past, when we don't know, when we don't have the information.
We just
you know,
table.
we
Just
table
table
to
it to the next meeting.
and-
Mhm.
and-
If they can't make it, then we'll, like Jay said, we'll re-advertise it to a future date certain. I'm
On a re-notification. Not.
no,
No.
no, not as a standard
If they were
operational
interested in
procedure.
the case, they would be here tonight.
Like you do.
We would post something on the web.
Yeah.
Our agenda will be posted on the web that indicates that the case is tabled to a date certain. But we wouldn't put the sign out front or the newspaper ad again. It would just be on the website. The tabling, the notifications do cost a lot of money. So,
I saw a meeting about that, I
Yeah.
said everything.
right.
Okay, then,
The staff would
We-
suggest just tabling it to the next meeting. And
Yep.
If they can't make that one, then, we may have to we'll probably re-notify this, re-advertise it.
thank you. Mr. Shaw?
I'm going to make a motion on behalf of the owner, CJ Investments LLC, the applicant, Andy Erickson. The address is 29 Kinsley Street. I am not going to read the entirety of the description of the 10 area variances. I think it's sufficient to say that there's a long list of items that are being covered in this, but this is mostly just a procedural motion since the applicant is apparently unavailable tonight. So I move to table this case till the next meeting, which is November 14th.
And I will second that motion. Okay. Mr. Lionel, how do you vote?
Mr. Lionel votes in favor.
Mr. Minkara, how do you vote?
Mr. McCray votes not in favor.
Mr. Boucher, how do you vote?
Mr. Boucher votes in favor.
Mr. Shaw, how do you vote?
Mr. Shaw votes in favor.
And myself, Mary Ellen McKay, I also vote in favor. It's 4-1, and the motion is tabled to November 14th. Okay. We have,
That was both cases. That was, yeah, I guess it was the whole thing.
yes, the entirety of
Right.
it. We have No motion for a hearing. We don't have an agenda because we're 3 weeks out instead of 2 weeks out. And so we have minutes. Has everyone had the opportunity to look at the minutes? Since I was not present, I will ask for somebody. Mr. Shaw?
Make a motion to approve the minutes of the October 10th, 2023 Zoning Board of Adjustment.
And Mr. Lionel? I will accept that, your second. Thank you very much. Mr. Boucher, how do you vote?
Mr. Boucher votes in favor.
Mr. Minkara, how do you vote?
Mr. Minkara votes in favor.
Mr. Shaw, how do you vote?
Mr. Shaw votes in favor.
Mr. Lionel, how do you vote?
Mr. Lionel votes in favor.
And myself, Mary Ellen McKay, I also vote in favor. And Josh, how did you feel on the minutes?
Everything appeared to be in order.
Okay, fine. We are all present and accounted for. I think that concludes the business for this evening.
Motion to adjourn.
Absolutely, it is. Let's look at the 8:39 and motion to adjourn. We are adjourned.